continue to you just don't give a shice about phone conditions, ma'am. Really? I mean, I get it that no means no. Doesn't mean, please, baby, get me out of jail. Every phone call is recorded. Take note if you continue to violate protective orders, we can have a hearing to hold you at no bond. Do you understand?
What you just witnessed was a judge pushed to the absolute edge. But what you didn't see is the year-long game of cat and mouse that finally caught up with Mr. Mendoza. This is State versus Mendoza. It begins with a simple 911 call, reports of a bloody nose. But the story quickly unravels. Was it an accidental injury caused by drugs? Or a deliberate strike with a closed fist? Mendoza insists he didn't know about his court dates. The record tells a very different story, one of a fugitive who vanished for nearly a year, hiding behind fake names to avoid accountability. Now the stakes are real, up to a year in jail, and the safety of a partner trapped in an 8-year cycle of violence. The question before the court is simple. Can this judge finally break the loop? To understand how legal professionals spot the tells of a career fugitive and the psychology that plays out inside a courtroom, hit that subscribe button. Now, let's go back to where this intense hearing truly began.
Hi, good morning.
I was appointed to Mr. Mendoza on your in-custody docket. He has 2 cases of assault, family violence that was a prior bond forfeiture, and a failure to ID. I was appointed this morning on those cases, and we have filed bail orders.
Okay.
On the we're requesting PR bonds, sir. On the old assault, family violence, he did let me know, he was in communication with his attorney, and the his appearances were being waived over an ERD court. I do show a reset from July 1st, saying he doesn't need to appear, and setting it for July 3rd, where he does need to appear, and his signatures are not on it, and he said he did not know. But
he picked up a felony violation of a bond condition.
That's correct, Your Honor. That was filed as a 2B warrant. Gonzalez.
I don't know anything about the cases, and I haven't spoken to him in a very long time. Does he speak English?
He does, yes, sir.
Great. I'm going to have him. Is he bringing him in? He has not made bond on the felony case, so.
That's correct.
Good morning, Mr. Mendoza.
Morning.
Sir, you're charged with 2 cases with us. You are charged with assault of a family member. You're now also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That allegation kicks it up to a Class A, so you're also facing a year in jail and/or a $4,000 fine. This case the assault is a year old. I have no idea what is going on with it, so I'm going to have you refresh my memory real quick. What happened, please?
On the AFM?
Please. On all 3.
So on the AFM, which is the original charge, on April 6, 2024, officers spoke with a complainant witness who stated she was involved in a physical altercation with the defendant after the defendant became upset with her over food and struck her several times with a closed fist in the nose and mouth, causing her pain and visible injury. Officer observed the complainant witness to have a swollen bottom lip with a small laceration, and she was holding a bloody towel that she used for her nose. Defendant was identified by his Texas driver's license, and the defendant and the complainant witness have been in a dating relationship for 8 years. So that's the oldest AFM. Do you want me to do the felony?
Yeah.
Okay.
What?
So on the felony, on June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complainant witness stated the husband threw her on the wall after she called his mom to complain of his behavior. Complainant witness said she had a protective.
I didn't hear any of that.
Okay. Officer, on June 4th, 2024, officer responded to a disturbance call and spoke with the complainant witness. Complainant witness stated that her husband threw her against the wall after she called his mom to complain of his behavior. And then she stated that she had a protective order against the defendant. And then the failed to ID. On April 11th, 2025, officer dispatched to an unknown disturbance call for service. Officers arrived on scene, knocked on the door. Officers observed a male come to the door, but quickly move out of the way, not wanting to answer the door. Officers observed the defendant walking out of the door stating that he was only having a verbal argument with his wife.
So
Officers-
now a new fight and that's what brings the cops to the house?
I believe so. Officer spoke to the female on scene. Officer stated the female was not answering questions due to not wanting to get the defendant in trouble. Officer observed the name and date of birth the defendant provided to officers for not coming through a TCIC search. Officers advised the defendant that if he does not have proper name and date of birth, he'll be charged with failure to identify. The defendant then confessed and provided his real name and date of birth. The defendant stated he did not want to go to jail for a warrant that he had. And then the officer observed that he had a felony and misdemeanor warrant.
The reason I'm trying to, you speak English, right?
Yes, sir.
The reason I'm trying to figure what's going on is because she's asking me to give you a PR bond, but we've given you bond after bond after bond. You've been in flight status for about nearly a year. And now when the cops come to try to talk to you, you try to evade again. You know what I mean? Are we just going to continue to give you chance after chance? You continue to you just don't give a shice about bond conditions, man. Really? I mean, I get it that he may have not signed it or whatnot, but you can't just be out of sight, out of mind for an entire year and expect good things to happen. So, I mean, really, we've given you PR bond after PR bond. It would just, at some point, I have to say when, so that we mean business. There's no more revolving doors, really.
The original AFN, it looks like they did do a RIP call. The complainant advised that the reason that she had a bloody nose is because she does drugs and was doing cocaine. He did have the PR bond. The VPO was a 2D warrant, so he wasn't given bond and didn't come on that one.
Yeah, but he had warrants up for both. Apparently knew about them. So
Well, it didn't say that he knew about the felony warrant.
Well, I don't know, but
warrant out.
But you can't make believe that he knew.
I mean, I can, if you want a bond reduction, I'm willing to give you a bond reduction. I'm not going to give you another PR bond, dude. Really. No more PR bonds. And you've got these cases out. Just, you can't out of sight, out of mind. And the only reason you're here now is because you got into another damn argument. So, Mr. Mendoza, I'm now issuing another protective order on this case. And I want you to understand that the Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold someone at zero bond. This is now one of those cases. If you continue to violate protective orders, we can have a hearing to hold you at no bond. Do you understand? I don't want you to have contact with this person. No means no. Doesn't mean, please, baby, get me out of jail. Every phone call is recorded. Take note when you're making phone calls. Every phone call is recorded. Do you understand?
Yes, sir.
I'm not asking for much. All I want are my streets to be safe. And if you can,
Yes, sir.
just don't have any contact, don't have any weapons, and that's it.
Sir.
If you want a bond reduction, I'm happy to give it to you, but I'm not going to just continue to give homeboy PR bond after PR bond after PR bond. Just not,
Would the court be willing to reduce the bonds for $1,000?
I'll cut it in half. So on the assault, 2,500. I'm going to leave the failure to ID as is. But I'm telling you now, I don't know if you're going to get out, but if you do, there is a residential restriction. You cannot go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
No alcohol, no illegal drugs. You will be randomly tested. No contact and no weapons. Do you mind? All I need you to do is file the MOA because we'll have him, pre-trial is going to, make sure that you're in compliance. All right, Mr. Mendoza. So what we'll do is the felony case is set for June. So what we'll do is, I don't like to set the people for more than 30 days so you just don't get forgotten about. We can set you for 30 days, come back, and then, go from there. Okay? All right. Yes.
The court has now issued its ruling. Mendoza was denied a personal recognizance bond but was granted a reduced cash bond along with strict residential restrictions. The central question, however, remains whether the court exercised excessive leniency in reducing bond for an individual who had been a fugitive for approximately 1 year. public opinion remains divided. Some view the decision as justified under the circumstances, while others believe it fails to adequately account for the victim's position. The victim's account, particularly regarding the alleged presence of drugs, has further complicated perceptions of the case and raised questions about what truly occurred. Ultimately, this ruling has sparked broader discussion about accountability, judicial discretion, and fairness within the bond system.